The crime occurred in the early morning of May 11, 1978. A recently engaged young white couple, Lawrence Lionberg and Carol Schmall, were abducted from a Clark Oil Company filling station in a mostly white Chicago suburb of Homewood, where Lawrence Lionberg worked as an overnight attendant. Their bodies were found the next day in an abandoned townhouse in a predominantly black East Chicago neighborhood known as the Ford Heights. Evidence showed Carol Schmall had been raped several times, and both victims were shot in the back of the head with a .38 caliber pistol. The crime shocked the nation because two white people were dragged to a predominantly all-black neighborhood, raped, and then killed. This crime is known as the Ford Heights 4 crime. Charles McCraney, who lived near the murder scene, told the police that Dennis Williams and two co-defendants, Willie Range and Kenneth Adams, had been in and around the abandoned townhouse about the time of the crime. Based on Charles McCraney's claim, police questioned a woman named Paula Gray, a 17-year-old girl. She was questioned for 2 days in a motel and testified before a grand jury that she held a disposable cigarette lighter burning while Adams, Range, Williams, and Jimerson raped Schmall 7 times, after which Williams shot both victims with a pistol. A month later, on June 19th, Paula Gray recanted her story at a preliminary hearing, claiming that her confession to the police and grand jury testimony had been coerced. Since Jimerson had been implicated only by Paula Gray, the charges against him were dismissed. Paula Gray was charged with murder and perjury and brought to trial jointly with the remaining 3 defendants, Adams, Range, and Williams. All 4 were convicted and rested primarily on the testimony of these 3 witnesses: Charles McCraney, who claimed to have seen them near the scene preceding the murders; Michael Podlecki, an Illinois State Police forensic scientist who said he had examined 3 hairs found in Williams' car. Based on the microscopic examination, Podlecki said 2 of the hairs were similar to victim Carol Schmall's, and the 3rd was similar to Larry Lionberg's. David Jackson. While Williams and Range awaited trial, a jailhouse informant came forward and claimed to have heard Williams and Range talking about raping a white woman and killing her boyfriend the night before. Jackson quoted Williams saying, "They'll never find the piston, you know. We ain't got nothing to worry about." Williams was sentenced to death, Range to life, Adams to 75 years, and Gray to 50 years. The convictions were affirmed on appeal. In 1982, Range and Williams won new trials based on their ineffective assistance of counsel, Archie B. Weston. While representing Williams and Range, Weston failed to file crucial motions and raise obvious objections. This led to their retrial. Prosecutors approached Paula Gray with a deal before Williams and Range's new trial, saying that she would be released in exchange for testifying against Williams and Range at their retrial. As a part of the deal, Gray also agreed to testify against Jimerson, who was then charged, convicted, and sentenced to death in 1985. 2 years later, Williams and Range were convicted a second time. Williams again was sentenced to death, Jimerson to death, and Range and Adams sentenced to life. Meanwhile, Northwestern University journalism students working the case under the direction of Professor David Protes obtained a recantation from Paula Gray of her testimony at the Jimerson trial and Williams' Range retrials. The following year, the Illinois Supreme Court vacated Jimerson's conviction, ruling that prosecutors had allowed their star witness, Paula Gray, to lie while testifying against Jimerson. Lacking credible evidence against Jimerson, the Cook County State's Attorney's Office agreed to DNA testing. More important, the students discovered a police file showing that within a week of the crime, a witness named Marvin Simpson had told the sheriff's police they had arrested the wrong men. Simpson said he knew who committed the crime because he heard the shots and saw the 4 men running away from the scene. The next day, he saw these 4 men selling items taken from the robbery and killings of the victims. Simpson identified the men as Dennis Johnson, Ira Johnson, Arthur Robinson, and Juan Rodriguez. Simpson's statement had never been turned over to the defense. An independent forensic re-examination by scientist Edward T. Blake established that Michael Podlecki's original testimony had been incorrect about the evidence and DNA found at the scene of the crime. DNA testing exculpated Williams and all co-defendants of the crime and pointed to Arthur Robinson, who confessed to the crime, and 3 other persons. One of those was by this time deceased, but the others were convicted of a double murder. In 1996, with the help of David Protess, Rob Warden, and a team of journalism students from Northwestern University, they helped uncover the truth that DNA testing exonerated all 4 men: Range, Williams, Jimerson, and Adams. In 1999, Cook County settled lawsuits filed by the innocent men for $36 million, at the time the largest civil rights payment in U.S. history.
This is where I hang out at most of the time, before when my wife was here, this is where I used to be. I try to stay in my own zone, but it seems like wherever I go, somebody always know, though, that I'm one of the Fort Heights 4.
The Fort Heights 4 were 4 young men who were convicted of the 1978 double murders of a young couple in Fort Heights. 2 of them were sentenced to death, Dennis Williams and Vernil Jimerson, and 2 were sentenced to life in prison, Willie Range and Kenny Adams. In 1996, they were exonerated and released from prison.
Yes! I'm free. Finally, I'm officially free.
I am sorry to these defendants personally and on behalf of the criminal justice system.
3 other men eventually were convicted as the real killers, and in 1999 they received what was then a record legal settlement, $36 million from the county.
As for Paula Gray, in July of 2001, her conviction was thrown out with a lengthy opinion by Circuit Court Judge William D. O'Neill. In 2002, Illinois Governor George Ryan granted her a pardon based on innocence. The pardon qualified Gray for approximately $100,000 in automatic compensation. Public and media pressure law enforcement agencies to solve a crime and successfully prosecute the perpetrator, especially in cases of horrific violence where the public has been outraged by its commission. In this case, 2 white people were kidnapped from a white suburban neighborhood, which created immense panic and concern in a number of nearby Chicago neighborhoods. Due to this public outcry, there was pressure put on police to find the killers and to make an arrest immediately. In this picture is Carol Schmall's body found in the nearby abandoned townhouse in Fort Heights. This picture circulated throughout newspapers, which created panic and therefore pressure on the police to find the killer. Noble cause corruption, which for our purposes may be described as an ends-based culture that encourages investigators to blind themselves to their own inappropriate conduct, and to perceive that conduct as legitimate in the belief that they are pursuing an important public interest. In this case, the abused their authority and held Paula Gray in a motel room for 2 days in order to extract a confession from her, which in fact led to a false confession. The police investigators received information from the eyewitness testimony by Charles McCraney that Paula Gray was a friend of the men he saw near the time and place of the crime. The investigators held Paula Gray in a motel for 2 days, where she falsely confessed that she had seen the 4 men rape and murder Carol Schmall and Larry Lionberg. She not only said that she had seen the 4 men do it, but implicated herself by saying that she was involved. This, in fact, was a false confession. In addition, Paula Gray tried to recant her statement, saying that whatever she said in the motel was false. Before the second trial for Range, Williams, and Adams started, the police had coerced her to tell that the 4 men, all of them, were involved with the crime in order for her to get time off or not sentenced at all with the crime. This led to a coerced confession. Eyewitness misidentification is the single most important factor leading to wrongful convictions. In this case, Charles McCraney believed that he saw Williams, Range, and Adams in and around the crime scene around the time of the crime. Testimonies from jailhouse informants has been highly scrutinized, especially in cases of wrongful conviction. Jailhouse informants are how they sound, incarcerated criminals that offer information and may receive incentives to testify. They claim to have heard admissions from the accused in exchange for lesser sentences or immunity from a charge. In this case, David Jackson lied about hearing Range and Williams talking about the murders in order to lessen his burglary charges at the time. On October 11, 1995, Jackson said he fabricated his testimony because, quote, I was offered a deal by Assistant State Attorneys Clifford Johnson and J. Scott Arthur. In addition to the police misconduct of extracting a false confession by Paula Gray, they also withheld evidence that would have proved the innocence of Range, Williams, Adams, and Jimerson. The Northwestern University students discovered a file showing that on May 17, 1975, 5 days after the crime, a witness had made a statement saying that he had seen 4 men leave the scene of the crime. The witness identified the 4 men by name. Ultimately, 3 of those men confessed and DNA corroborated their confessions. Michael Podlecki, the state serologist, testified that 3 of several Caucasian head hairs allegedly recovered from the backseat and trunk of Williams' car matched the hair of Lineberg and Schmall. He used the words similar and matched, where the prosecutor went further into stating flat out that the hairs came from the victims. The prosecutors alluded that this was factual evidence, therefore displaying what is known as culture of the crown. Culture of the crown places paramount value on winning and the culture of winning through a strategy, in this case alluding to facts that are not properly evidenced and raising a theory inconsistent with facts and evidence. Hair analysis is not purely objective, and it cannot distinguish one individual to the exclusion of all others. Forensic evidence that deals with hair analysis is no longer used as a method of identifying someone. Edward T. Blake, an independent forensic scientist, proved that Michael Podlecki's testimony was false and that the hairs found at the crime scene did not link to the victims. Exculpatory evidence is evidence in a criminal trial that tends to show that a defendant is not guilty. In this case, alibi witnesses testified that Williams, Range, and Adams were elsewhere when the crime occurred. Range's girlfriend testified he was with her at his home at the time of the crime. Adams' mother and Williams' mother testified that their sons were at home sleeping. Williams and Range's first defense lawyer, Archie B. Weston, failed to file crucial motions and challenge prosecution contentions. The ineffective assistance of counsel led to Williams and Range's retrial.
What they all share was this experience of the anger still sort of trailing after them, that while it may recede, it doesn't disappear entirely. They still can get angry over it. They don't think about it as much, but when they do, it still angers them. When you got out, were you angry at the people, the prosecutors and the police?
They asked me that, and I walked away from that interview. I refused to answer that. What y'all say? I plead the fifth.
Did the settlement, the money that you received, make everything right?
No, I was born without money. I'm gonna die without money. Like I tell my wife, if it's about the money, take it all. Just leave me enough to live, because I'm finna be 57. The way the system got me set up, 21 years, I'm supposed to be dead anyway.
Miscarriages of justice undermine public confidence and jeopardize the integrity of the justice system. Governments often respond by engaging in a policy-making process to improve and avoid wrongfully convicting those that are innocent, such as the Ford Heights 4. Unfortunately, some reform initiatives are superficial at best, as they do little to address and eradicate the inherent systemic flaws in our justice system that contribute to wrongful convictions.